The petitioners have urged that the order of this court dated 27 June 2022 relied on the decision in Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions. This submission cannot be accepted. Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions in view of the principles of natural justice. Based on the submissions which have been canvassed before us, we are of the view that the decision in Nabam Rebia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam Rebia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rebia. 1. Whether the temporary disablement of the functions of the Speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And 2. Whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench: whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, adoption of the following procedure may subserve the objective of the 10th schedule, the symbols order, as well as Article 179C. It may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications which require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 ko correction hai, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3, the decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party which reaches the halfway mark forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve 2 objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable. And such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shiv Sena was chaired by Mr. Uddhav Thackeray in his capacity as the Shiv Sena President, Party President, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the president of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the president of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the legislative party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the Speaker inferring that there were two factions of the Shiv Sena. The Speaker, on taking cognizance of the resolution passed by the faction of the SSLP led by Mr. Shinde, did not attempt to identify which of the two persons who were nominated, namely Mr. Prabhu or Mr. Gogaole, were authorized by the political party. In a contentious situation such as this, the Speaker should have conducted an independent inquiry based on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. For the reasons detailed in the preceding paragraphs, the Speaker must only recognize the whip appointed by the political party. The decision of the Speaker recognizing Mr. Gogaole as the chief whip of the Shiv Sena is illegal because the recognition was based on the resolution of a faction of the Shiv Sena legislature party without undertaking an exercise to determine if it was the decision of the political party. Harmonizing the 10th schedule with paragraph 15 of the symbols order. This court cannot accept the solution proposed by the petitioners and lay down a constitutional sequence. To hold that the Election Commission of India is barred from adjudicating petitions under paragraph 15 of the symbols order until the final adjudication of the disqualification petitions under the 10th schedule would be in effect to indefinitely stay the proceedings before the Election Commission of India. This is because an order of the Speaker attains finality only after all avenues for appeal have been exhausted or are barred by the passage of time. The time that it would take for an order of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutionally entrenched institution which is entrusted with the function of superintendence of and control over the electoral process. The ECI, which is a constitutional authority, cannot be prevented from performing its constitutional duties for an indefinite period of time. Proceedings before one constitutional authority cannot be halted in anticipation of the decision of another constitutional authority. In arriving at this decision, it is not necessary for the ECI to rely on the test of majority in the legislature alone. In cases such as the present one, it would be futile to assess which group enjoys a majority in the legislature. Rather, the Election Commission of India must look to other tests in order to reach a conclusion under paragraph 15 of the symbols order. The other tests may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. Then we deal with the judgment in Sadiq Ali's case, and having dealt with the judgment, we say the disqualification proceedings before the Speaker cannot be stayed in anticipation of the decision of the ECI. In cases where a petition under paragraph 15 of the symbols order is filed after the alleged commission of prohibitory conduct, the decision of the ECI cannot be relied upon by the Speaker for adjudicating disqualification proceedings. If the disqualification petitions are adjudicated based on the decision of the ECI in such cases, the decision of the ECI would have a retrospective effect. This would be contrary to law. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both the factions of the Shiv Sena claiming to be the real Shiv Sena. In effect, this points to the existence of a split within the SSLP. However, no faction or group can argue that they constitute the original political party as a defense against disqualification on the ground of defection. The inevitable consequence of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members who face disqualification proceedings. In cases where a split has occurred in a political party or in a legislative party, members of neither faction may validly raise the defense that they are the political party in the event that each faction files petitions for the disqualification of members of the other faction. The defense sought to be availed of must be found within the 10th schedule as it currently stands. The deletion of paragraph 3 impacts the proceedings under paragraph 2(1)(b) as well. When there are two whips appointed by two or more factions of the political party, the Speaker, as held in the preceding section of the judgment, decides which of the two whips represents the political party. Thus, the adjudication of the Speaker on whether a member must be disqualified under paragraph 2(1)(b) would also depend on the decision of the Speaker recognizing one of the two or more whips. We accordingly answer the question referred to us as noted in paragraph 32F of the judgment. To avert a no confidence motion, the incumbent government may not advise the governor to convene a session of the assembly, and the Speaker may adjourn the sitting of the House to prevent voting for granting leave to move a motion of no confidence. If the Speaker and the government attempt to circumvent a no confidence motion, the governor would be justified in exercising the power under Article 174 without the aid and advice of the Council of Ministers. Now we have dealt with the role of the governor in the present case. The petitioners have urged that the governor was not justified in reaching the conclusion that he did on the basis of the resolution dated 21 June 2022 because 1. The 34 MLAs belonging to the Shiv Sena did not express their intention to exit the Maha Vikas Aghadi government, and 2. The MLAs who signed the resolution constituted a faction of the SSLP. Although the resolution dated 21 June 2022 specifies that some MLAs of the SSLP were dissatisfied with the functioning of the MVA government, it does not record their intention to withdraw support from the government. Among the 34 MLAs who signed the resolution dated 28 June 2022, a few were also ministers in the government. On the basis of this resolution, the governor concluded that a majority of the Shiv Sena MLAs have given a clear indication that they intend to exit from the Maha Vikas Aghadi government. The assembly was not in session when Mr. Fadnavis and 7 independent MLAs wrote to the governor. However, there was no attempt made by the members of the opposition parties to issue a notice for a no-confidence motion against the incumbent government. The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the MVA government. The communication expressing discontent on the part of some MLAs is not sufficient for the governor to call for a floor test. The governor ought to apply his mind to the communication or any other material before him to assess whether the government seemed to have lost the confidence of the House. We use the term opinion to mean satisfaction based on objective criteria as to whether he possessed relevant material and not to mean the subjective satisfaction of the governor. Once a government is democratically elected in accordance with law, there is a presumption that it enjoys the confidence of the House. There must exist some objective material to dislodge this presumption. The MLAs did not express their desire to withdraw support from the MVA government in the resolution dated 21 June 2022. Even if it is assumed that the MLAs implied that they intended to exit from the government, they only constituted a faction of the SSLP and were at most indicating their dissatisfaction with the course of action adopted by their political party. The political imbroglio in Maharashtra arose as a result of party differences within the Shiv Sena. However, the floor test cannot be used as a medium to resolve internal party disputes or intra-party disputes. Dissent and disagreement within a political party must be resolved in accordance with the remedies prescribed under the party constitution or through any other methods that the party choose to opt for. There is a marked difference between a party not supporting a government and individuals within a party expressing their discontent with the party leadership and functioning. The governor is the titular head of the state government. He's a constitutional functionary who derives his authority from the constitution. This being the case, the governor must be cognizant of the constitutional bounds of the power vested in him. He cannot exercise a power that is not conferred on him by the constitution or a law made under it. Neither the constitution nor the laws enacted by parliament provide for a mechanism by which disputes amongst members of a political party, particularly, can be settled. They certainly do not empower the governor to enter the political arena and play a role, however minute, either in inter-party disputes or in intra-party disputes. It follows from this that the governor cannot act upon an inference that he has drawn that a section of the Shiv Sena wished to withdraw their support to the government on the floor of the House. It is true that the letter dated 25 June 2022 sent by some MLAs of the Shiv Sena to the governor requesting him to issue directions to the appropriate authorities for the restoration of their security details mentions that those MLAs no longer wanted to be a part of the corrupt MVA government. However, this cannot be taken to mean that they had withdrawn their support on the floor of the House. Nothing in any of the communications relied upon by the governor indicates that the dissatisfied MLAs from the Shiv Sena intended to withdraw their support to the Chief Minister and the Council of Ministers. At the highest, the various communications expressed the fact that a faction of the MLAs disagreed with some policy decisions of the party. The course of action they wished to adopt in order to air their grievances and redress them was at the time the floor test was directed to be conducted uncertain. Whether they would choose to enter deliberations with their colleagues in the House or in the political party, or mobilize the cadres, or resign from the assembly in protest, or opt to merge with another party was uncertain. Therefore, the governor erred in relying upon the resolution signed by a faction of the SSLP MLAs to conclude that Mr. Thackeray had lost the support of the majority of the House. Second, the governor relied on the letter dated 25 June 2022 from 38 SSLP members, claiming that the security provided to them and to their families was illegally withdrawn. The MLAs claimed that the security was withdrawn to coerce them into continuing to support the MVA government against their free will. Therefore, they demanded the restoration of the security provided to them and to their family members. After receiving the letter, the governor issued directions to the state police to provide adequate protection to the MLAs, the members of their families, and their property. However, the lack of security to the MLAs has no bearing on the question of whether the government enjoys the confidence of the House. The appropriate response of the governor in such cases is to ensure that security that they were lawfully entitled to continues to be provided to them if it has been removed. This was an extraneous reason that was considered by the governor. The third communication that the governor relied on is the letter dated 21 June 2022 addressed by Mr. Eknath Shinde to the Deputy Speaker, stating that the appointment of Mr. Ajay Chaudhary was illegal. The governor may not inquire into or express an opinion on the validity of proceedings of the legislature. That is exclusively within the domain of the legislature itself, or in certain circumstances, discussed in the previous segment of this judgment, within the domain of courts. The discretionary power of the governor under Article 163 of the Constitution is limited to situations where a constitutional provision expressly provides it, or where the Constitution cannot be construed otherwise than to grant such discretion. Hence, the governor ought not to have relied on the letter dated 21 June 2022. In any event, the contents of the letter did not indicate anything to suggest that the then Chief Minister, Mr. Thackeray, had lost the confidence of the House. Finally, the governor relied on the letters written by Mr. Fadnavis and 7 independent MLAs, calling upon him to direct Mr. Thackeray to prove his majority on the floor of the House. First, both Mr. Fadnavis as well as the 7 MLAs could have well moved a motion of no confidence. Nothing prevented him from doing so. Second, a request by some MLAs for a direction to the Chief Minister to prove his majority does not, taken alone, amount to a relevant and germane reason to call for a floor test. There must be some objective material in addition to a mere request to call for a floor test. In the present case, the governor did not have any objective material before him to indicate that the incumbent government had lost the confidence of the House and that he should call for a floor test. And the exercise of discretion by the governor in this case was not in accordance with law. Now on relief. Relying on Bommai and Nabam Rebia, the petitioners argue that this court has the power to restore the status quo ante and rule that the government with Mr. Thackeray as its chief minister is to be reinstated. However, this argument does not account for the fact that Mr. Thackeray did not face the floor test on 30 June 2022 and submitted his resignation. This court cannot quash a resignation that has been submitted voluntarily. Had Mr. Thackeray refrained from resigning from the post of the chief minister, this court could have considered the grant of the remedy of reinstating the government headed by him. The order of this court dated 29 June 2022 held that the outcome of the trust vote to be conducted on 30 June 2022 shall be subject to the final outcome of this batch of petitions. Since the trust vote was not held, the question of it being subject to the final outcome of these petitions does not, therefore, arise. Conclusions. In view of the discussion above, the following are our conclusions. A. The correctness of the decision in Nabam Rebia is referred to a larger bench of 7 judges. B. This court cannot ordinarily adjudicate petitions for disqualification under the 10th schedule in the first instance. There are no extraordinary circumstances in the instant case that warrant the exercise of jurisdiction by this court to adjudicate the disqualification petitions. The Speaker must decide the disqualification petitions within a reasonable period. C. An MLA has the right to participate in the proceedings of the House regardless of the pendency of any petitions for their disqualification, the validity of the proceedings of the House in the interregnum is not subject to the outcome of the disqualification petitions. D. The political party and not the legislature party appoints the whip and the leader of the party in the House. Further, the direction to vote in a particular matter further, the direction to vote in a particular manner or to abstain from voting is issued by the political party and not the legislature party. The decision of the Speaker, as communicated by the Deputy Secretary to the Maharashtra Legislative Assembly dated 3 July 2022, is contrary to law. The Speaker shall recognize the whip and the leader who are duly authorized by the Shiv Sena political party with reference to the provisions of the party constitution after conducting an inquiry in this regard and in keeping with the principles discussed in this judgment. E. The Speaker and the Election Commission of India are empowered to concurrently adjudicate on the petitions before them under the 10th schedule and under paragraph 15 of the symbols order respectively. F. While adjudicating petitions under paragraph 15 of the symbols order, the ECI may apply a test that is best suited to the facts and circumstances of the case before it. G. The effect of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members facing disqualification proceedings. The Speaker would prima facie determine who the political party is for the purpose of adjudicating disqualification petitions under paragraph 2(1) of the 10th schedule, where two or more factions claim to be that political party. H. The Governor was not justified in calling upon Mr. Thackeray to prove his majority on the floor of the House because he did not have reasons based on objective material before him to reach the conclusion that Mr. Thackeray had lost the confidence of the House. However, the status quo ante cannot be restored because Mr. Thackeray did not face the floor test and tendered his resignation. And I, the Governor, was therefore justified in inviting Mr. Shinde to form the government at the behest of the BJP, which was the largest political party in the House. This batch of writ petitions is disposed of in terms of the conclusions and directions recorded above.
Grateful to your Lordship.
Immediately. Without correction.
Deep life.
No, no, blight. Deeply obliged.